I haven't read the thing yet, so.
It's starting.
Okay, so
Okay.
welcome to season 1, episode 8. Trusted partner, business partner, Sonia.
Hello.
My name's Richard, if you know already.
And I'm Sonia. So today we're just really gonna speak about the common mistakes people make with estate planning.
Okay.
And we found a lovely, well, it's not a lovely case study. We found an applicable, relatable article.
Yeah.
That we'll refer to today. So I will be reading that out, and then we'll just have a discussion on that. So, Richard, just to begin with, a lot of people, they have wills. They think, they're sorted. They have their will in place, who they want their staff to go to. They have their insurance in place, everything, and they think, you know what? Yeah, I'm sorted. When the day that comes, when I do pass, my family will be okay. There's some things that are overlooked, though, unfortunately. So what I'm asking you, do you have a few notes of what the common mistakes are for estate planning?
Yeah.
But what could you say that are the biggest mistakes people make, or things that people overlook in estate planning?
In my experience, it's either leaving things till late because they just think, oh, we don't need to think about that until later on in life, or they have a will and they think that it's one size fits all. It's a will, it does what it says in the tin, and they don't really know what's inside, what it contains. Lack of knowledge and poor advice, really, that they've received in the past. So people just don't know what they don't know.
Mm-hmm.
And then if they get the information, it's sometimes later than they expected it to be.
Yeah.
And yeah, just poor previous advice or just lack of awareness altogether. Really.
Mm-hmm. So also, I do have people think a will completely does the job, but people don't necessarily know that they may need a trust alongside their will, which would also be very important. And another thing is people don't usually update their will. What would you say would be the recommended time to regularly update your will?
I would say review it every 3 to 4 years, or a major life event. So you get married, get divorced, move home, have children, increasing wealth, lump sum income received, or along those type of scenarios. Whereas addition to the family, children, grandchildren, great grandchildren, or a major like government or legal change, where you need to review if it's going to affect your wealth, your assets, your business. That's where I would say, look, you need to review what's going on.
Okay. And another thing is a lot of people, they don't want to necessarily spend the money.
Okay.
Some people, I'd say, I don't want to use the word stingy, but they don't want to spend that money to have the correct advice.
Yeah.
I think a lot of people, they just think, you know what, a will's a will. I'm just going to go to the most price suitable person out there that fits my budget. But then if you pay a cheap price for a will, you are going to get a cheap quality will.
Yeah.
The same with a trust. So unfortunately, that's another mistake a lot of people make. People just think a will is a will. They don't know the depths of what a will should have.
Right.
And they don't know how vital having a will is after they do pass. So I'm just going to read out this very, very interesting article. It's not too long, probably just about a minute or two.
No, take your time.
All right. So, younger lover of Herbalife tycoon wins legal battle over his 6.4 million fortune. Glamorous partner 58 defeats the multi-millionaire's 3 siblings in high court as judge rules she can keep every penny after the 78-year-old's death. So, he died in 2021, aged 78, leaving his 6.4 million fortune to his partner, 58 years old, with whom he had entered a civil partnership with weeks earlier. But his will ended up at the centre of a court fight in London with his siblings claiming a share. The trio claims the wife had failed to honour promised to their brother that if he left her his entire estate, she would then do right by his family by splitting his money with them. They claimed he only left her money because she had an abhorrence for paying tax, and her much younger age made it a tax efficient way of passing on his fortune. However, his wife's lawyers argued that the courts cannot enforce moral obligations. A High Court judge has now thrown out the case, meaning she can keep every penny.
Right.
The court heard that that part. So although previous wills left his siblings a share, in 2020 he made a new will leaving everything to his wife, with whom he then formed a civil partnership with, so she would not have to pay inheritance tax. There was no discussion of a will being imposed, let alone who the beneficiaries are and should be, the terms of any trust or property to be subject to it. The only reason he left everything to his wife, unlike in previous wills where his fortune was also shared with his siblings, was to avoid his family having to pay tax, he said. He added there was an agreement after his death that his wife would give money to his siblings because she was still relatively young, and the gifts would be tax exempt. There was no evidence he changed his mind or intended to cut them out, believing that his wife was 100% honourable. So that is a very unfortunate situation. Do you have any thoughts on that?
Yeah, I mean, people change when it comes to money. Money's like alcohol, it accelerates people's kind of natural nature. And then unfortunately, not speaking ill of this woman, but if she made an obligation or made a promise and not honoring it, it happens. And I think a lot of family members I speak to, they trust their family members implicitly. They believe they know their children inside out or their loved ones inside out, and it will never happen. And so they refuse to have anything like, clauses in the will or anything specific. Or a lot of people just don't like trusts in their will. Even though you try to explain it, they just don't want it. They believe that their children are super honorable. I'm not saying they're not, but it happens, especially when there's a large sum of money. People change. It's just family dynamics change. People get greedy and vultures start to come out, and people rubbing their hands ready to receive. And it's just one of those things. You hear about it too often.
Yeah.
Too often.
So when she promised she'll do right by his family by splitting the money with his siblings, that should have been stated in a trust.
Yeah.
Should have been stated in the will as well.
Depends. I mean, if you didn't, I'll probably with that length of money. It depends on how much this individual wanted to invest. It sounds like he didn't want to invest that much money in planning, so we don't know.
Yeah, because he was just trying to avoid the tax by giving it to her.
We don't know what kind of advice he received. We just don't know. Lots of speculation, but and things like specific gifts in wills, if there's no trust, I'm not a fan of it personally, but that could have been done, and that would ensure. But if inheritance tax was the priority, then he wouldn't want to make any gifts to his siblings. A wife is exempt as a beneficiary, so she would have received that 6.4 million free of any inheritance tax. So the understanding was that the siblings should receive it through her distribution. Then a will could have been set up, but a trust would have had to have been in play of some form to make sure that they're named as beneficiaries after she's the primary beneficiary, or something along those lines.
And also just to clarify for those viewing and for those that may not know, when you're married, when you're in a civil partnership, if one person passes away, all that wealth gets transferred to either their husband or their wife.
As long as it's stipulated. Because if you've got a government will, that's not necessarily the case. So when I say government will, under the rules of intestacy, that's not necessarily the case that 100% of the money goes to the surviving spouse. But if it's stipulated in writing via the will, then yeah. But the law says that they're deemed as exempt, but it has to be planned. It's not by accident. It's not a natural occurrence. If no will was written and you have a husband and wife or spouses together, it's not a natural thing for the surviving spouse to get 100%,
Yeah.
unless there's no children.
Okay.
Unless there's no children. So it's really important that it is stipulated.
And also, just to reread this part again, there was no discussion of a trust being imposed, let alone who the beneficiary should be, the terms of any trust, or the property to be subject to it.
Yeah.
So one of the biggest mistakes that he made was obviously not considering a trust, and I'm guessing that was probably due to lack of knowledge.
I'm going to err on that side. Yeah, I want to what's the word I'm looking for? Give the benefit of the doubt and assume that they weren't advised. Or, or they might have refused that. But I'm assuming I'm going to go by they weren't advised. Yeah.
So what I'm obviously assuming, I could be wrong. He just knew that he needed to do some sort of estate planning, and he thought probably a will would do it for his estate, which is massive. 6.4 million is a lot.
Yeah.
He just thought a will would do it, and he doesn't know. He doesn't know better, because it's clearly backfired for him. And the person he went to for that estate planning clearly didn't give him that advice.
Well, we don't know.
We can't assume. Yes.
Because some very stubborn clients sometimes just don't want to do it. You can recommend. But obviously, according to the evidence, nothing was mentioned that they were advised and they refused. So we only can kind of guess or one can guess what could have happened. We don't know.
But it's just like there's a few people out there that would give you what you want, but not what you need.
Exactly.
So you go to them and say, I need a will. They would give you the will.
Yeah.
But they wouldn't probably advise you further on how important it is to probably put a trust in place.
So just to challenge them and question them, to get them to think.
Also, now I'm a bit confused on this area. So I don't know if you can clarify that for me. Right. So it also says there was an agreement that after his death, his wife would give the money to his siblings because she was still relatively young, and the gifts would be tax exempt.
Yeah.
So what has her youth got to do with it being tax exempt, the gifts?
Well, all I can think about is the gifts to her from spouse to spouse is tax exempt. She's a surviving spouse. And then it's £6.4 million. So let's say she was going to distribute £1 million to each sibling, for argument's sake.
Yeah.
She just has to survive 7 years, but because she's young, the probability of her surviving is much, much higher. So I think that's what that point is making out. 7 years at age 58 should be 65, and it's completely tax exempt. That 6.4 million or £3 million that she gives to the siblings. So that's a decent plan. So inheritance tax is paid on the death of the second spouse, if it's decent planning. And if there was an agreement for that, even for the private one, for her to distribute whatever was promised to the siblings during her lifetime, the technical term is a potentially exempt transfer. So because the money is hers, she'd be making a gift during her lifetime to another individual. So we call that a potentially exempt transfer. So revenue will class that as fully exempt from inheritance tax unless she dies within 7 years of that gift being made. And if she dies within 7 years of that gift being made, then it becomes a chargeable transfer, at which point it is subject to tax on death, up to 40%, depending on when she passed away from making a gift.
Okay, so just to cover what you were saying, because I'm trying to summarize it in my head. So if she was older, let's say she was the same age as her husband, in her 70s, and she wanted to make that gift. Obviously the time frame is 7 years. She would be taxed if she died within the 7 years. So when they said that
tax exempt.
Yes.
So any gift you make to another individual, that's an important point, another individual, is called potentially exempt transfer. It's a bit of a misnomer. It's completely exempt when you make the gift,
Mhm.
unless you die within 7 years of making that gift.
Okay.
So that's what that statement means. It's an exempt gift.
Okay.
Yeah, it's tax exempt
Mhm.
unless you die within 7 years of making that gift.
Okay.
Then it will become chargeable to tax.
Okay. All right then.
Yeah.
Thank you. So just to go back to the article as well.
Yeah.
It says that her lawyers argued that the courts cannot enforce moral obligations. A high court judge has now thrown out the case, meaning she can keep every penny. So is that true? They don't take any moral obligations into consideration?
You can't compel someone because there's no proof.
Yeah.
That's what I mean by moral. There's no proof. It's not written down. There's no evidence of even a trust by parole, like a verbal trust. There's no secret trust. It's hard. Obviously, this court couldn't find any evidence that was either an agreement, a written agreement, a verbal agreement that all parties could agree to there's some kind of precedent to say there's evidence that it was agreed that something would happen. There's a famous case.
Can I just interrupt you before you get into that?
I can think of the case while you're talking. Go on.
So let's say he's siblings that wanted to share where his children.
Yeah.
Would the court consider that?
It'd be a different claim. Yeah. Because siblings by law, the 1975 Inheritance Act, by law don't have the right to make a claim. So the claim would have been on some kind of a breach of the trust the will or some kind of influence or something along those lines, but it wouldn't have been under a claim of a beneficiary that's been disgruntled.
Okay.
If it's children,
then
they'd have a right to make a claim.
Okay.
If he had disinherited them,
okay,
then the court could have intervened, but they would have to look at the situation and the circumstances around it. Yeah.
All right then. All right. So do you want to continue for?
No, yes, of course. There's a case called Paul v. Constance. Don't ask for the year. But it was literally a very similar scenario, but they weren't married. So it was Mrs. Paul, Mr. Constance. Mr. Constance was married. Mrs. Paul was his mistress. He won some money from the bingo, from memory, and I think they were planning to go on holiday or something along those lines.
Yeah.
And he verbally made the agreement because they put the money in the bank account. In those days, women couldn't be jointly named on a bank account. So he put the money in the bank account in his name only, albeit he's a married man. But he says to his mistress, Mrs. Paul, that this money is between you and her, Mrs. Paul and Mr. Constance. Then he goes and dies. He passes away. So now Mrs. Constance, his legal wife, makes a claim, which she can do, that the money's hers. But because there was evidence that a verbal agreement was made, because a trust, technically speaking, can be created verbally, but must be evidence in writing, or the court can construe a trust exists. In this case, in Paul versus Constance, the court construed a trust exists. The judge even commented, forgive the politically incorrectness, but even someone with a blue collar status can create a trust. So like a lower status in that time. So ultimately the court sided with Mrs. Paul or Miss Paul, the mistress, that the money was hers and not the wife, because a trust was in existence. So there was no moral obligations in that case. It was clearly evidence, and the court could go back in the history and look at the facts that an agreement was made and of trust existed.
With the mistress, did you say?
With the mistress, yeah. So in this case, and there's loads of cases that kind of, back that kind of evidence up, and even the Law of Property Acts talks about something similar in Section 53. So as long as it's written down, then it must be honoured. But in this case, there's obviously no evidence of an agreement, so a moral obligation can't be enforced. Where's the evidence? It's almost hearsay. So I can understand why the judge could not really make a decision. There's no kind of case law to support him to side with the siblings in this instance. From my understanding, I'm not a lawyer.
Yeah,
I'm a lawyer. I'm not a solicitor. Sorry, so I don't practice law in the court. I'm not a barrister. But from my understanding of case law, I can't see why that would be. The judge had no other choice but to rule in the favour of the mistress, of the wife. Sorry.
Yeah. So just to cover, what steps should he have taken to prevent that? Would you say?
He could have created a secret trust. He could have put it in writing,
Mhm.
like a deed, some kind of just agreement to say between the siblings and the wife and him to sign that
Yeah.
it's agreed. So it's outside of the will, but there's cases to support that, and that would be classed as a secret trust. And so the court would look at, well, what was done first, and who is the actual beneficiary.
Yeah.
And the court would have construed, equity would have construed who's supposed to receive, but obviously nothing was
Done. Yeah.
So equity can't side with that, unfortunately.
There's
a difference between just and fairness, you see.
Yeah.
You've got to do the right thing.
Right. Well, thank you.
Yeah, no,
that's really insightful, because that is a very common situation.
It is.
A lot of people do go through that, and I've heard a lot of stories.
Yeah.
When usually the husband will pass away, and the wrong person, either their mistress, would potentially get their wealth instead of their partner if they're not married to them. Depends. Every situation is different.
Yeah.
But yeah, it's quite sad to hear, and especially this case with the 78-year-old man.
Yeah.
It was said that in his previous wills, he had put his siblings to get a share of his estate.
Yeah.
It was then his previous wills, but he changed it because he wanted to avoid tax.
That's a really important point here. Now, I don't know when the previous will was written, but marriage will revoke any existing will. Like, it's null and void.
Yeah.
So obviously creating a new will revoke any previous wills. So that's also important for people to be aware of. Like, those life events of getting married will revoke a will, unless it's been stipulated in the will of contemplation. But yeah, it's just poor.
I think he was trying to do a cheat code.
It sounds that way.
It sounds
you can
like
make the presumption.
Because he just wanted to avoid tax, but not actually, well, from what I'm understanding.
Yeah, but I feel, and sorry to jump in there, as advisors, professional advisors, we should challenge clients to think. And then if they refuse, that should be noted down. So I think it goes both ways.
Yeah.
It goes both ways. Even though he could assume they were doing it on the cheap, we don't know.
But here it says that it was to avoid paying tax.
Right. So then that was the right advice to some degree, that it goes to the spouse. But if he stipulated and was very adamant, but it also says that he trusted that his wife would do the right thing, and she's not doing it.
So could he have still done that and then just have the trust?
I would have always recommended. I would say that I would have pulled him to one side and said, "Are you 100% certain? I know you trust your wife and not being disrespectful, but people do change. Are you 100% certain that your wishes will be honoured without being stipulated in your will?
Yeah.
Would you not want to have the instructions there so the executors, even if your wife is an executor, would know what to do? Say she lost capacity.
What's going to happen?
Who would know
then?
what the agreement would be?
The least that he could have done is put it in writing.
Exactly. Absolutely. Like, you just can't leave anything to chance. Especially if you don't honour your promise.
Yeah.
You can't leave anything to chance, because that's a big deal. So if she lost capacity, who would know that the agreement was honoured? If it's not written down. Yeah. So trust has nothing to do with it. It's let's get down to the facts. Prevention is better than cure. I'd rather prevent the matter, or even prevent anyone having to deal with that situation, because you've removed it from ever happening, because it's written down. So yeah, I think it's really important.
Yeah. Well, thank you so much.
No.
If you want to read the article, would it be in the?
Yeah, I'll drop the link. It came out today. It's a Daily Mail. I'll drop the link somewhere in the description, so you can catch up and just read it for yourselves.
Okay.
No problem.
Yeah, and we'd like to obviously hear what you think as well.
Yeah, definitely. Put your comments below. I'll be really interested. If you've got any questions as well, that'd be really good.
Yeah, please don't hesitate to reach out. And even if you find something interesting, share it with us. Do you know what I mean? Definitely. It would be a great topic to discuss in another podcast. So
without doubt.
Right, I think that's it.
Awesome. Well,
thank you so much.
Appreciate it. Cheers.